state constitutes no objection to the prayers made by counsel for A1 and A2. Your Lordship, we must set the record very straight here now that the state cannot be planning to amend an indictment on this 29th day of December of 2025, and also simultaneously pretend that they were always ready to proceed. A state that has not served the signed copy of the indictment, they are choosing, that is even still pondering whether to amend and which details of the indictment to amend, is simply not ready for trial. And Your Lordship, any suggestion that somehow the accused by exercising their rights to insist on a fair trial, sabotages or delays trial is disingenuous, incompatible with the Constitution, but also flies in the face of their manifest, the state's manifest and readiness. So we have a unique situation here whereby even if the accused wanted to or could read, there is nothing to read to now as we speak. I don't even think it is necessary to serve the accused an indictment that they know they are going to amend. Logically, why not serve the indictment on the basis of which you want to conduct trial and stop taking us through motions, because this is serious business. We are not here for any ritual. We so pray.
My Lord, Mr. Jatik has conceded explicitly that the judgeship before you is defective. He has conceded, rather the indictment he wants court to proceed on this morning is defective. He has conceded. My Lord, in the trial, according to the Trial Indictment Act, the particulars must be clear. The particulars of the accused persons must be accurately captured in the indictment. Now he has indicated they intend to amend the indictment, cure the defects. But at the same time, it sounds illogical and irrational. And I think that's why he explained himself from moving the court to proceed. He said he is leaving it to court after realizing that actually the court cannot proceed to administer a plea on a defective charge. That's the very reason, my Lord, we should not proceed. Secondly, my Lord, we are surprised he has not responded to the issue of one of the signature of the register. And section 61, which I have just read out in the TIA, it's mandatory that the indictment must bear the signature. of the signature of the registrar. And section 61 my lord, the TIA, ready together with section 28 which spells out the particulars that must be captured in the indictment. And this specifically, my lord, subsection 1 and 2 of section 28, every indictment shall bear the date of the day when it is signed. And subsection 2 of section 28, the registrar of the High Court shall give the accused person and the director of public prosecution reasonable notice, not being less than 14 days. Section 28, the TIA. I read subsection 1, which is providing for the date, the exact date when the registrar signed. It must be there. And the indictment before you, on which you want us, you wanted the court to proceed, is not signed by the registrar. Neither does it bear a date. That this is the date it was signed by the, obviously it couldn't have a date because the registrar has never signed it. That the registrar must give adequate notice, must serve it. Of course, the same will be served on the accused persons and the DPP at least 14 days prior to the proceedings. And this all was not done, my lord. All this was not done. So it would be fatal, my lord, for this court to proceed to administer a plea to death. It would be fatal. And good enough, the prosecution seemed to be conceding to this. As submitted, that will occasion miscarriage of justice. So we pray that you be pleased to defer the matter.
At the time when the accused persons were being committed to stand trial before this honorable court, they were given copies of the indictment. My lord, the prosecution does not sign on behalf of the registrar. My lord, this is power reserved for the registrar. And my lord, it is not for the prosecution to serve a signed copy to the defense, because this is the power restricted to the court. So, my lord, I think this is misconceived. My lord, the matter has been raised about the particulars of F3. And my lord, particularly, the accused person has been in possession of his indictment since he was committed, and these matters were not raised. It is just being raised before this court, before the plea is taken. And my lord, it is prudent for the prosecution to have this amended as to his name and end. So, my lord, and my lord, it becomes further difficult with the presence of all these many applications after applications which have been before this court, to have these amendments done before the matter is actually set for proceeding. And it is also not true that today, the 29th of December 2025, it is also not true Like my learned friend said that he did not expect the prosecution to amend it today. We are not saying we are amending it today. We are proposing that we will have this anomaly in the process of this matter proceeding. But this cannot be done when there are numerous applications after applications.
I have very carefully listened to the submissions of both council, so the person, and the state. I will now proceed to make the following remarks and findings. That regardless of several applications that were filed by the persons, from the court report, the status of this case has been for plea taking from 1st September to date. Although court at a given time will proceed to handle several applications and expose the same, but the status of this session number 335 has been plea-taking. Therefore, not true that the parties are ambushed. I have already made a ruling in application number 814, guiding that plea-taking in simple terms is for a accused person to plead to the indictment, and court is able to know whether the accused admits or denies the allegations. I want to be clear at this point that I was in my ruling that let us separate plea-taking with other procedural steps. Counsel for the accused person have submitted that the accused was not served with a copy of the indictment. However, I have looked at the lower court file. I will quote, when the accused was committed on 29th May, the judicial officer who was committing the accused person said that upon committal, the accused persons are given copies of the indictment. There is evidence, therefore, that from the time the accused persons were committed, they were given copies of the indictment. It is my opinion and stand that the accused persons were duly served with a copy of indictment as it is required under Section 61 of the Trial of Indictment Act. On the issue of pending bail for S3, I have never met any law or any provisions of the law that bail is a bar to plea-taking. Even if we follow the practice, it has no harm. It doesn't produce a chosen person like S3 to take plea and thereafter apply for bail. Otherwise, bail cannot be used as a bar to plea-taking. I have again stated in the application number 8 of 14 of 2025 that the bail can be handled at any stage, and it is the accused's liberty and their counsel to make an application to that effect. But to keep mixing bail as a part or stay as a part for the accused persons to plead under Section 61, it is, in my view, not proper. I will now turn to the issue of amendment of the Trial of Indictment Act. I will quote Sections 51(1) of the Trial of Indictment Act states that every objection to an indictment for any form of defect on the face of it shall be taken immediately after indictment has been read over to the accused person, but not later. This section is clear on that. Section 51(2) of the PIA scheme states that if court is made to appear that indictment is effective or otherwise requires amendment, court may direct this in order 51. So in the view of the above reasons, this court is satisfied that two persons were clearly served during committal with a copy of indictment. Two, this court also is satisfied that the case has been pending pre-taking since 1st September. So it's not true that there is an ambush to the party. Accordingly, let the accused persons, and I am telling the defense and the accused person that let us go ahead and take plea, then other questions can follow, and so on.